If you look at access to justice, there are different kinds of injustices that can happen. All this while during my presentation I mentioned about injustice due to economic distress or weakness, but there is another kind of a person who is suffering from a duration weakness. Now, duration weakness means a person who cannot sustain the delay in the proceedings. For example, a person with a old age, he will not go to court thinking that during his lifetime he may not get the justice. A married woman, now she wants to take a divorce and lead a different life altogether away from her husband who is continuously harassing her. She cannot imagine getting a divorce in a matter of few months and so that she can get back to her own life. Now, these are the people who cannot survive the delay in the proceedings. We need a legislation to address both these requirements. So, coming to economic weakness, we have two options. Economic weakness can be addressed by a legal aid, that is under Legal Services Authorities Act. Under Civil Procedure Code, it can be redressed by exempting them from paying court fees, and that is what I am going to discuss in today's discussion as to how far these court expenses are meted out. Then comes duration weakness and how to address that. That is done by speedy process. So, we need to increase the speed of justice, and whether that is been done, that is what we are going to look into. So, Constitution, I will just browse through it. This is about the preamble which provides for a justice which is social, political and as well as economic, and this instructions or the mandate is not only for the legislatures, it is also for the judiciary, and they have to ensure the justice, social, economic as well as political. So, remaining with the Constitution, Constitution provides for two types of access to court. One under Article 32, wherever there is a violation of fundamental rights, we can directly go to Supreme Court and seek for redressal. The second is the Article 226, where the fundamental rights or any other rights, if they are violated, they can directly approach their respective high courts. So, this is where the Constitution does its brief job as to access to courts. Coming to the speedy process as a justice for the poor. So, this speedy process becomes a very important tool for protection of rights in criminal proceedings. The right for speedy process becomes meaningful, or it gains much bigger, larger meaning when it comes to a situation where the liberty of a person is being deprived due to arrest, due to denial of bail. So, therefore, speedy process has been a right, constitutional right under United States of American Constitution. So, therefore, the difference between the USA and Indian legal system is in USA it is speedy process is a right, but in India it is being inserted into Indian Constitution through judicial interpretations. Even though status wise both are same, but there is been a recommendation by NCRWC which is trying to incorporate speedy trial as one of a fundamental right by bringing in a new article number 30A, but it is still in pipeline and hope that it will see the light of the day. Now, coming to the speedy process and our judicial observations. The person you are seeing on the slide is Justice P.N. Bhagawati. The justice, when he was writing a judgment for Kadra Pehadia versus State of Bihar, he was amused with the delay and the inhuman approach of the judiciary. In his own words, I want to quote, Justice Bhagwati said, "It is a crying shame upon our adjudicator system which keeps men in jail for years on end without a trial." He went on to criticize the judiciary, his own judiciary, and added, "No one shall be allowed to be confined in jail for more than a reasonable period of time. We fail to understand why our justice system has become so dehumanized that lawyers and judges do not feel a sense of revolt at caging people in jail for years without trial." These are the words of Justice Bhagwati, where he is expressing what we call it as a judicial regret for what is happening in our justice system. The next justice, the Justice Krishna Iyer, he speaks about a procedure called a slow motion syndrome. So he says our justice system, even in grave cases, suffers from slow motion syndrome, which is lethal for fair trial. So he is actually bringing in a correlation between slow motion syndrome leading to unfair trial. Now that relationship is very important to note, that wherever there is a delay in the proceedings, there is injustice happening to the person. Husainara Khatun versus the state of Bihar. Now here again the court said that if a person has spent as an under trial in a jail more than the maximum punishment that can be given if proved guilty, then he has the right to be, there is a violation of his fundamental right under Article 21. So therefore, Judicial Observations in Katar Singh versus State of Punjab, the court came up with the conclusion that speedy trial is an essential part of fundamental right to life and liberty. So from speedy trial, let us move on to legal aid. Khatri versus State of Bihar, they said that a court held that a state is constitutionally bound to provide legal aid, not only at the stage of trial, but also when they are first produced before the magistrate or remanded from time to time. So legal aid is a process or a service which a person is entitled at the stage of arrest onwards, not only at the stage of trial. Now let us have a circular understanding of, cyclic understanding of importance of legal aid, how important a legal aid is. So let us look at a situation where there is no legal aid. A person comes to a court who is suffering from a lack of finance. So lack of finance leads to lack of representation, or at least poor representation. This lack or poor of representation leads to lack of arguments or poor arguments. This absence of arguments or absence of putting forth his own point of view effectively can lead to miscarriage of justice, because I will be speaking on this point at the later stage also. Justice can be done by the judge only if he is supported efficiently by the bar, the effective intelligent bar. So judge alone cannot do justice in absence of support from the bar. So therefore lack of finance leads to lack of representation, lack of argument, and finally miscarriage of justice, and this leads to exploitation, and again the cycle continues. Exploitation further leads to lack of finance. So this is the importance of legal aid for our purpose. So let us move on to civil procedure now. Now civil procedure and access to justice by poor. In the civil procedure code, they have used the term indigent person for defining or for representing or naming the poor person, and who is an indigent person. So, there are two qualifications to call a person as an indigent. Number one, he has no means to pay, or a property is valued less than 1000. So, these are the two qualifications, and these qualifications comes into picture at two different situations. No means to pay becomes a qualification to be an indigent person if the fees have been prescribed. If no fees is prescribed, then the indigent person the indigent person will be declared where the property is less than 1000 rupees. So, these are the two situations which leads to indigency under Civil Procedure Code, and the indigence of a person is recognized both at the original suit as well as at the appellate stage. The Order 33 of CPC provides for indigence support in original suit. Order 44 provides for the support at the appellate stage. Now, let us look into what kind of support that they extend. The support that CPC extends for an indigent person is exemption from court fee. Only because a person is not able to pay court fee, he shall not be denied of justice. He can come before a court, prove that he is indigent, and then continue with the case without paying court fee. Now, does the court readily agrees? No, the answer for this is no. The moment a person makes an application to be declared as indigent, the court conducts its own inquiry into it, and after satisfaction only he would be declared as indigent. Further, the court takes a serious view of indigency. Why I call it as a serious view? Because the status, that is indigent status, can be reviewed at any stage of the proceedings, and in the review if they find that he has overcome that indigency due to some changed circumstances, then immediately the court will ask for him to pay the court fee, and status of indigency would be withdrawn. So, it is not a judgment, it is not an order which is suffering from res judicata. It can be reviewed at any stage at any time, and it can be reviewed at any number of times.